Okay, Robert, what do we start with? Do we start with, I think it's a trilogy, right? With the Biden lawsuits that were filed, and I think maybe it's going to be the best series to start with because one's going to lead into the other, and there's a few of them. So look, for those of you who don't know, the Biden, do we call it the Biden administration or just the government in its ARPA giving COVID relief to restaurant owners, had basically said, we're going to give $29 billion in relief to restaurant owners and restaurateurs who have been suffering under COVID. This is the policy that they were enacting under, I'm going to forget the acronyms, but you'll get it when you clarify my mistakes. They basically say we're going to give $30 billion to restaurant owners for the losses that they have sustained due to the government regulations shutting them down, et cetera, et cetera. With a but, they say we're going to prioritize not disenfranchised groups, but marginalized groups or the most disaffected groups, I guess, for lack of a better word. And they say so we're going to prioritize restaurant owners that are women and restaurant owners that are, I say marginalized groups, but it basically comes down to minorities, ethnic visible minorities, which under the evidence that the government produced to justify the policy effectively comes down to saying white people have had historical advantages for getting loans from banks, et cetera, that it basically means it's going to be everyone except for white people who are going to, white males effectively, because females are prioritized under this as well. They're going to get not extra benefits, just advanced access to the benefits. So for the first 21 days, marginalized groups and women can apply for the grants. What ended up happening within 9 days, they basically promised or gave away $9 billion of the 28. And they basically said, look, it's all gone. Like, it's all basically going to be guaranteed to the groups who apply in advance, who are marginalized groups and women, etc. Someone filed suit and said this is pure discrimination because even before this $30 billion, which is supposed to be divided among the businesses who have been affected, before it can even get there, it's all guaranteed, earmarked away to groups that discriminate for no logical basis. I didn't read the underlying lawsuit, but I mean, that's I think, good enough.
Yeah. I mean, basically, This was the America First organization founded by Stephen Miller that brought suit first on behalf of farmers, then brought suit about for restaurant owners and bar owners. Only difference being that for the farmers, it was no white people need apply, period. Whereas for restaurant owners and bar owners, there was no white men need apply. And it was a great win. The court said this is obvious discrimination. It doesn't meet the compelling interest standard. You didn't even go through and meet the metrics for that. You didn't show how that was necessary because they likely could not, and enjoined it. And so it was a very big win right out of the gate against the Biden administration's own application of critical race theory and government application, which was going to determine whether or not you could get relief for COVID, particularly lockdown-related reliefs that are mostly passed by Democratic governors based on the color of your skin or your gender. And the court said that clearly is unconstitutional. And that's what we predicted would happen, by the way.
Well, and it's I say encouraging, but it's not. The problem with these debates is that they immediately become racialized, because if you say it's a good decision, you sound like, and we're both white men, you're going to sound like white men who are angry that the government is trying to rectify historical wrongs to the extent that you adhere to that belief in the first place. Following the evidence, what's interesting in this case is that they went through the evidence that Congress or whichever the government officials, used as a support for the policy. And it basically said, historical prejudices, historical wrongs, historical discrimination, the inability to procure loans, a number of things which I think most people would probably agree with. But the judge said, good, even if we accept this, these are not specific to the restaurant industry. So these, if they apply to society at whole, they don't apply necessarily in the context of relief that is designed to target restaurateurs. And so, I guess the idea is, it's a compelling position, is if you want to do what is effectively, what's the word for writing reparations? If you want to do reparations, do it distinctly by law and let people know that that's what it is, but don't do reparations, basically disguised reparations through COVID policy, because that's effectively what this was. And the judge said, if all of this is true, none of it applies specifically to restaurateurs, and therefore there's no rational connection between the discrimination and the policy.
Exactly. And my view is they would have established that factual record if they had it. And my view is they know they don't. They just wanted to, discriminate in favor of certain groups based on race and gender, and that's what the Constitution does not allow outside of exceptional circumstances that simply are not present here.
Does this, because this was filed by the same individual who filed the farmers lawsuit, right?
Or the same group, so different plaintiffs, but the same group.
And now, does this is in Texas as well? So does this give an indication as to where the Texas farmer suit is going to go? How does it impact that?
Yes, it almost guaranteed the farmer suit they will win as well. So it'll be two big wins right out of the gate for the America First Legal Foundation, established by Stephen Miller, and very good restrictions right away on the Biden administration's attempt to racialize distribution of government resources.
And now, any lasting impacts on the government, or do they just try to do this again, but in, I don't know, another jurisdiction where another judge might take to it more favorably?
It'll be tough for them to do that. These are federal policies, so they can keep suing in Texas. So I think that, they can try to get it reversed on appeal, and they may. I think that would be risky for them because now they're set up to lose across the board in ways that make very clear they can't do it. So we'll see. But I think that I don't see how the judge's ruling can be overturned, not in a way that's consistent with our case law or our Constitution. So it's always possible these days, but I think it's improbable.
And now, actually, maybe clarify this as well, because it's a distinction that exists under Canadian law, but maybe some people who are watching don't fully appreciate it. The latitude of a court of appeal in overturning a decision of the lower courts when it comes to matters of fact, matters of appreciation of evidence, and matters of law, there's a different threshold, and maybe it would be good to clarify for anybody who may not appreciate that.
For these purposes, it would be de novo review because he granted the temporary. Now, I mean, the injunction a little bit different, but because this was basically done on the law primarily. There wasn't an evidentiary hearing, to my knowledge. There wasn't a trial or anything like that. So they defer to judges on factual findings, but not legal conclusions. And so these were all legal conclusions. So they don't have to defer to them. But it's just once a court has established it and the logic is pretty impeccable, it's difficult to overturn without opening up Pandora's box, that they can just say, well, in the past, there have been bad things happen to this group, so we're just going to distribute resources solely to this group. And again, this was supposed to be COVID relief. This wasn't supposed to be reparations bill. And so the trying to do this through COVID relief was itself problematic. There are additional problems. They didn't define what percentage certain socially disadvantaged groups is how they defined them. It does 20% black matter, 40%, 5%, and it particularly, it's the current identitarian politics doesn't quite fit into this legally, because what if people just identify in certain ways? For example, these days I identify as vaccinated. So, who knows how that works. It
is just amazing to see how in your face it is in terms of policy. It's good to see some courts standing up to it, but it is in your face, divisive, and I do not believe anybody who even believes in the legitimacy of these types of laws. I don't believe that any discrimination is really justified unless it is necessary by the essence or nature of the institution. But even the people who believe in it cannot deny or cannot be unaware of the fact this is going to create further racial divide and further discord among society. You have everybody who's suffering. Everybody. And someone's going to say, well, you're suffering less because of the historical benefits that I presume your family has gotten, not knowing if you're first generation white versus, or if you're Irish or whatever it is. It's just going to create discord. And I do wonder if the cynical part of me wonders if it's not to some extent by design, or they just don't care. Like they think that it's just, they're going to get enough of the majority at some point that they don't care if they're basically dividing and conquering.
Yeah, I mean, to me, it's sort of political extension. It's protecting their own political voter groups over others. I mean, I think that's a lot of what was going on, and as well as disguised reparations. But they wanted the green light to discriminate however they wanted, and the court struck it down, which was the correct decision. And that might transition into the next big Biden loss, which was on the taxes. Because the other thing he was trying to do was use COVID relief to prohibit states from cutting their own citizens' taxes. And that, too, the court said was clearly unconstitutional, was an attempt to commandeer the state for purposes that the 10th Amendment does not permit or allow. And so that was another excellent decision and another limitation. The Biden administration's effort so far to circumvent the Constitution and issues of immigration, lockdowns, taxes, state policy, and racial policy so far are mostly losing in courts, which is a good early indicator that courts are actually going to enforce the law and not allow them to get away with what they're trying to do, which is rewrite the Constitution without an amendment.
And now, is this the case that we discussed last week, which was commandeering, but requiring a state? I think it was Texas, Mississippi, Alabama, basically saying if you're going to get the federal funding for COVID relief, you cannot issue any sort of state reduction in taxes. That was what we discussed last week, right?
Exactly. So we predicted that these cases would win, and they both won within a week.
Okay, because I know I feel like I'm going totally senile because I know we discussed it, and I don't think I did a video on the lawsuit itself, certainly not on the judgment. So, I mean, what was the essence of the judgment? Pretty much straightforward application of well-known existing law?
Yep, same deal. It was, the judge stepped in very quickly, could have waited, stepped in very quickly and struck it down. Said, no, you can't do this. You've known you can't do this. Don't try it. So it was major judicial restraints from a body that people were nervous would not really try to restrain this administration in the way they restrained the prior administration. But at least early decisions are good. Also, that may have also been in Texas as well.
I think it was. It's interesting. It's almost like, in a cynical way, the government just says, let me see what I can get away with, and then I'll pull back. Or it's a win-win to some extent, or it's a no-lose situation. See what you can get away with. If it gets struck down, nice try. You don't have to pay for anything. It's all on taxpayer dollars anyhow. And see and test the limits of the court. So and that's an interesting thing. So federal cases, because all of these are federal policy, the plaintiffs can pick pretty much any state they want. It's not as though any federal policy would have a specific state jurisdiction for some reason.
Yeah, and I hear Democrats' anti-Trump legislation or litigation is going to come back to bite them because they established a lot of these precedents. They went venue shopping aggressively and abusively, and they established the precedents that now can be used against them.